Jury deliberations in the trial of the men accused of killing Ahmaud Arbery got underway this afternoon. Less than an hour ago, the judge sent the jurors home for the night. 3 white men face a 9-count indictment that includes charges of malice murder and felony murder. They chased and gunned Arbery down in February of 2020 while he was jogging in the neighborhood. The trial has been closely watched amid the ongoing reckoning over racial justice. Attorneys made the final push yesterday to persuade the jury, and the prosecution delivered its final rebuttal this morning. Here's some of what each side said.
Greg McMichael pulled no trigger. How could the state seek a conviction for malice murder as Greg stood in the bed of the pickup truck on the phone with 911 as the fatal shots were fired?
They know what they did. It's not like they don't know what they did. They know exactly what they did, and they know why they did it. It's not a mystery to them. When you come back with your guilty verdict, all you're doing is telling them, we know what you did too. And we're going to hold you responsible for it. Because guess what you did? You turned this young man into that young man. That's what you did. For absolutely no good reason at all.
The outcome of this case now rests on the shoulders of the jury. Will justice be served, or will the defendants walk? Joining me now to talk more about the details in this case is BNC Justice correspondent Candace Kelley. Candace, thank you so much for being here tonight on AMplfieid. Now, defense attorneys have tried to build a case around self-defense. Obviously, the prosecutor has argued against that. Is there any merit to the self-defense claim, and how well did the prosecution combat that approach?
Listen, the self-defense claim had no merit, Aisha. I mean, if we think about what's going on here, we are looking at 3 defendants who essentially were chasing Ahmaud Arbery, saying, wait, I need to claim self-defense once I track you down. And that makes no sense. No sense. Here we have a situation where if you read the law, and that's what was in favor of the prosecution, the law. Either you argue the facts, you argue the law, or somewhere you find yourselves kind of just stamping your fist on the table, trying to figure out what's going on. There was a lot of stamping of the fist on the table, but then there was also the prosecution who in a very professorial way explained each of the charges. And I can't see any way that you can go wrong on those charges, especially when it comes to the fact that this citizen's arrest law did not apply to these 3 defendants in question. They didn't see a crime that was taking place. There was no immediate knowledge of any crime that happened within the time that they were chasing Ahmaud Arbery. So the way that the prosecution laid it out, the way that the defense laid it out, it only makes sense that the prosecution would get a check off in the box, I think, in all 5, or actually there are 9 particular charges, but 5 specifically that were charged over and over again in terms of the crimes. And I think that they checked the box in all of them in terms of the malice murder, the felony murder, the kidnapping, the and all of the things that they were charged with. I think that the prosecution.
Yeah, tell me more about the charges that each of these men face. What's the difference between malice murder and felony murder?
So with malice murder, you have this whole idea that as they carried out the killing, and there does not have to be any intent on either the felony murder or the malice murder, but as they carried out the killing, they did it with a malignant heart. Translation, it was reckless behavior in how they carried it out and how they went about going after Ahmaud Arbery. Felony murder means that you killed someone in the commission of a felony. The underlying felony here being aggravated assault with the rifle, aggravated assault with the car, and then false imprisonment, because all 3 of them got him and cornered him like a rat by their own testimony, and cornered him. So you have that false imprisonment claim, and those are the underlying felonies. Felony murder and malice murder carry the same sentencing of the 30 years. So when we look at it that way, I think that one of those boxes is checked, because listen, think about it. By their own admission, their own testimony written, their own testimony that was spoken to the police, they told on themselves this was a Christmas gift come early for the prosecution, and that all 3 defendants spoke on record saying exactly what they had done to break the law.
So could William Roddy Bryan actually see a lighter sentence than his neighbors Travis and Gregory McMichael? And can you explain that?
So this is the argument that Kevin Goff, his attorney, was making. He has essentially, since the beginning of the trial, wanted to separate William Roddy Bryan. Why? Because then he has a more likelihood of not being really a party to the crime. And Georgia is one of these states that they call party to the crime state, that you're kind of wholly responsible. As Linda said, everybody gets a guilty Super Bowl ring, even if one person does pull the trigger, for example. So when we look at William Roddy Bryan, he is the person who has the highest likelihood of getting a lesser charge, because Attorney Goff, even though he was kind of off his rocker for some of the arguments that he made during this trial, during closing, he was very succinct and kind of brought it home by saying, listen, William Roddy Bryan, he's really not that bright. In fact, he was sitting on his porch and he was working on some things. He came out, he didn't know what was going on. He didn't know they had a gun. He couldn't have seen it from his car, which the jury might believe him. He didn't know they were going to shoot someone, which someone from the jury might believe in. So he does have a chance, and not only on these higher charges, but then 2 lesser charges were added in terms of simple assault as well as reckless driving, and those could stick. But he's the one who has the most gain in those lesser charges.
Well, let's talk about the defense attorneys here. Laura Hogue, in particular, who represents Greg McMichael, made some pretty disparaging comments about the victim in her arguments. And here, I'm going to play a little bit of what she had to say.
Turning Ahmaud Arbery into a victim after the choices that he made does not reflect the reality of what brought Ahmaud Arbery to Satilla Shores in his khaki shorts with no socks to cover his long, dirty toenails.
What in all what was she actually trying to do here? And is this ultimately going to help or hurt her client's case?
Well, listen, these attorneys, they're the ones who actually see the eyes and not the mouth and the face, because they're using masks, by the way. They see the eyes of the jurors and they can read them. She must have read something in that jury to let her know that she could do that, because this was just, it was despicable. It was racist. It reminded me of how slaves were sold, putting them on a block and looking at their toes, looking at their hands, looking at their skin. And we heard a little bit about that, how his legs and thighs were, how he was in such good shape. So, you know, this is something, too, that I think that she should be sanctioned for. You know, she kind of tried to slip in this evidence. Now, you asked what she was trying to do. Well, there were records of Ahmaud Arbery and his mental health and his mental record. And I think that she was trying to draw a correlation that someone who has dirty toes and dirty toenails and everything and looks like they haven't kept up with themselves and can't manage themselves, that this is someone who mentally may not have been all there. So I think that even though she couldn't get the evidence in of his mental history, she, in a very slick way, did it here. Now, this judge is very liberal in terms of letting the attorneys on both sides kind of get their theories in, but this was really just below the belt. It was, you know, I understand why Wanda Cooper-Jones left during this part, but she was able to move herself through the part showing him after he had died, because this was just such a low blow for a mother who had clipped the toenails of her baby when she was little. To think about this, and we know as African Americans, when we go out in the world, our mothers and fathers wanted us and needed us to be clean, to be well kept, and to make sure that people knew that that someone cared about us. And so to hear this, I'm sure that her heart just must have sunk, which is why she got up and left the room.
And to your point, there's everything about race and racism to me suddenly in that comment. You know, speaking of race, 11 whites and just 1 black juror will determine the trial outcome. How could the makeup of this jury panel actually impact the verdict?
Listen, it's going to impact it in a very large way. We have, as you said, young black. Now, studies have shown that even if you have 1 African-American person on a jury, that certainly does help, and it decreases the sentencing phase when somebody is an African-American defendant and things of that nature. Here, We don't know the Black person that we're dealing with, though. We don't know anything about them. Black people are not a monolith. We don't know what they will represent in terms of the African American community. My guess, being from the South, perhaps they can be a spokesperson, as we all have been for our entire race in that room. But it does make a difference that they at least have one. But as you said, when we talk about race and when we look at the makeup of this jury or the Rittenhouse jury, we have to look at these peremptory challenges and figure this out after this is done to figure out why we have these two juries with 11 whites on both and then one Black when there was an equal selection system. Everybody filled out the same questionnaires. Everybody came and went through the voir dire process, yet we ended up with just one Black person in a town in Brunswick that's 29% African American. That's an impossibility to look at those statistics in terms of it making sense and in terms of whether or not justice makes sense in this situation.
Indeed. Candace, while I have you, I want to turn quickly to the civil case involving neo-Nazis and white nationalists who organized the deadly 2017 Unite the Right rally in Charlottesville, Virginia. After a trial that lasted almost a month and 3 days of deliberations, the jury found the defendants liable on 4 counts of violence and reached no verdict on 2 other claims. First, what was at the center of this case and what made the plaintiffs file in the first place?
So what was at the center of this case was whether or not that rally in Virginia, the Jews will not replace us, Virginia, right, with the khaki pants and the white shirts in Charlottesville, whether or not that rally was there, that there was a conspiracy behind it in order to incite and create violence in and around race or religion. Was there a conspiracy was the key question here. And this is what 9 plaintiffs said there was. 9 plaintiffs ultimately won $26 million. Now, compared to what they were asking for, not so much, but this really makes a statement in terms of what you can do when you are designing a protest and what you can actually get away with when you are at a protest and you cause havoc and death the way that they did back in 2017.
Could you tell us about the 2 counts that the jury couldn't actually reach a verdict on?
Right. So they couldn't reach a verdict on the fact that, and I say fact because I don't see how otherwise they could not have seen this, that there was a conspiracy charge in order to create or incite violence in and around race. They decided that those 2 particular charges in and around race, that had not been proven, even though there was testimony, there were podcasts, there were texts, there was information from the Discord app. There was information all over the place that they were able to look at, but they said that based on race, that did not fly. They did say that the lesser charges in terms of just pure intimidation and harassment and harm and causing that to a person, that they were found guilty on that. But when it came to race specifically, somehow they decided otherwise. Something that the defendants would say was probably a win, but the plaintiffs, I promise you, are saying that this is a win in their eyes. Before they actually had this rally, there are communications on Discord by the creators of this rally that if they needed to crack skulls, let us do it. And in fact, someone's skull was cracked. There was information that showed that they looked up what it meant when someone drove into a crowd of people. And what do we know about Heather Heyer? She died because of a car that was driven into a crowd of people. So this 26 million means a great deal, especially for future protests. And that's really what we're talking about. Protests, what happens at protests around America and how we protect ourselves around them. And now what people can actually get away with. This is really unprecedented, a very, very big deal.
What effect do you think this is going to have, this verdict is going to have on the white nationalist movement? It's going to have a chilling effect at all?
I do think it's going to have a chilling effect. They will think twice about the communications that they have because their defense was First Amendment. And hey, we were just joking. We were just joking about death. We were joking about cracking skulls. But now they're on the hook for $26 million. Many of them have already said how financially crippled they have been along the way. And now, after the verdict, they have to pay a total of $26 million. By the way, there were a couple of dozen defendants in here. Some of them were individuals, some of them were organizations, but they are all on the hook. And this means that even if they don't have the money, which a lot of them said, look, the money to pay anybody, for the next 20 years of their lives, if they make money, then some of that money will belong to the 9 defendants who actually pressed charges against this group. So this is definitely something that you do not want hanging over your head. The inability to go out and make living, the inability to be free and mobile the way that you want and just grow as a human being because you know you've got this financial attachment and burden on you for the next 20 years of your life. So a chilling effect, as you said.
Wow. Thank you so much for boiling down all of these details of these cases. All eyes are certainly going to be on what will happen next. Candace Kelley, BNC Justice correspondent. Such a pleasure having you on tonight. Thank you for being here.